Good day good day everyone. I'm Bruce Hornsby. I'm the host today for sexual harassment in the legal profession. A CBD as part of the ongoing program by the Law Society of Yukon for Professional Development. Today, I'm pleased to join us Birju and Amna who are both from the Human Rights Commission. Birju is Director of Human Rights. And he's originally from Calgary, Alberta. He has extensive academic and practical experience in the field of human rights, an LLB honors from the University of Wales, a postgraduate diploma in professional legal skills by the City of London University, City University of London, and LLM in public international law from the London School of Economics and Political Science. Additionally, Birju has spent time studying at the Honorable Society of Gray's Inn, Cambridge University, and the School of Oriental and African Studies. Birju's previous experience includes Assistant Director of the Alberta Human Rights Commission, teaching fellow in the Faculty of Law in Oriental Studies, University of London. The son of refugees from Uganda, Birju has a lifelong commitment to advancing the cause of human rights and is pleased to have the opportunity to support the Commission in doing so. Amna is working as a human rights officer for the Yukon Human Rights Commission. Amna moved to Canada in 2016 after finishing a BA LLB honors at from Lahore University of Management and Science in Pakistan. She completed her LLM at Osgoode Hall Law School while interning with the Ministry of the Attorney General. After getting licensed as a lawyer in Ontario, Amna completed a legal advisor placement at Lawyers for Human Rights in South Africa. In that position, she undertook a large-scale research project for the gender equity program. One of which was examined the unique vulnerabilities of female migrants in South Africa, and was published in a peer-reviewed report. As a human rights officer at the Commission, she investigates cases of discrimination harassment under the Yukon Human Rights Act. She also undertakes inquiry consultations and assists legal counsel by conducting research, drafting documents. Moreover, she supports the public legal education work by giving presentations and contributing to the Commission's workplace sexual harassment projects. So we're pleased to have them join us. We're booked for an hour and a half. There's a Q&A function, so if you have any questions, please feel free to answer them. And with that, we'll just get rolling with it. Thank you for being here today.
Good afternoon, everyone. My name is Amna, and this is Birju here with me. I will just be sharing our screen now.
Are you able to see our screen?
Yeah, I can see it.
Perfect.
Great.
I guess to put out the question that will come up inevitably, will these slides be available later?
Yes, absolutely. So we will be sending our presentation to Lynn at the conclusion of this afternoon session, at which point you can be expected to be circulated shortly thereafter.
Thank you very much.
And my understanding is also that this session is being recorded for everyone viewing it later as well to have access to the slides. Okay, so we are working at the Yukon Human Rights Commission, and we'll be going over sexual harassment in the legal profession today. I am Amna Bhatti, I'm the Human Rights Officer, and co-presenting with me is Birju Dattani, who's our Director.
And just before we begin the presentation, we'd like to start with a land acknowledgement. We are honored to live, work, and travel within the traditional territories of all 14 Yukon First Nations. We respectfully acknowledge that Whitehorse is in the traditional territories of Kwanlin Dun First Nation and the Tanquachan Council. Je reconnais respectueusement que je vis et travaille au sein de territoires traditionnels de la Première Nation Kwandundun et de Conseil Tanquachan. With that being said, I'm going to turn it over to Amna for the first half of our presentation, and I will be rejoining you again for the second half.
So just before we begin, just a few points to note are that this presentation is for general information purposes only, and the Yukon Human Rights Commission provides legal information and not legal advice. And we also understand that we will be talking about sexual harassment and some topics and conversations which some people may find uncomfortable or triggering. And in that case, we fully understand if you want to take a moment and step away from the presentation. And if you have any questions afterwards, the Yukon Human Rights Commission, you can call us, email us, contact us in multiple ways to ask us about human rights in the Yukon or any questions about workplace sexual harassment. So we'll begin by going over basically what the commission does. So the Yukon Human Rights Commission is an arm's length statutory agency that promotes equality and diversity through research, education, and enforcement of the Yukon Human Rights Act. The main things that we do are public education. We have a complaints process, research, policy information, and partnerships. I'm not going to read this slide, but one important thing I would want to note is that as part of our public education mandate, we are working on a project, on a major federally funded project, a 5-year project, and we're in year 2 of that right now, about workplace sexual harassment in the Yukon. It's called A Yukon Without Workplace Sexual Harassment. We recently had, in March, we had a conference as part of the project, and what we basically want to accomplish is to create awareness and to create a general understanding of what workplace sexual harassment means, and to develop goals in partnership with other organizations to bring about a cultural shift in Yukon about workplace sexual harassment. I'll give an overview about the agenda of this presentation. First, I'll go over what harassment means and the black letter of the law about workplace sexual harassment in the Yukon under our act. And then Birju will take over and he will talk about sexual harassment specifically in the legal profession and what all of our responsibilities are.
My apologies. I just got, there was just a notice in chat that the audio is sort of hollow, and maybe if you move to the right, it would be a little bit better. I guess there's some echo on the mic. Thanks very much. Sorry for the interruption.
Sure. How's that? Is that better?
Certainly sounds better. Certainly does sound better to me. Thank you very much.
Okay, excellent.
So what is harassment under our act? So under section 14 subsection 2 of the Yukon Human Rights Act, harassment means to engage in a course of vexatious conduct or to make a demand or sexual solicitation or advance that one knows or reasonably ought to know is unwelcomed. This slide does split it into some important parts that we will go over in the next few slides. But basically, what does a course mean and what does one knows or reasonably ought to know is unwelcome means? We will go over that. And then another important thing to note about harassment under our act is that it must be related to a protected ground and a protected area within the act. And we'll also go over that in a brief moment. So a landmark case on workplace sexual harassment is Jensen, 1989 Supreme Court case where Justin Dixon basically stated that sexual harassment in the workplace may be broadly defined as unwelcome conduct of a sexual nature.
Sorry for interrupting again. I just got another notice in chat that said, and it also appears to me that perhaps the slides aren't advancing.
Sorry, say that again, Bruce.
There was just a comment in the slide in the chat that doesn't appear. The slide shows advancing. It's a slide that's on the screen, not the slideshow.
Oh, I see. Let's take a look. Just wiggle the mouse a little bit. Let's see if screen sharing is on. Maybe hit escape quickly. You are screen sharing.
Yeah.
I wonder if there's a bit of a lag time. Bruce, can you perhaps describe for me what's on your screen or what you're seeing?
I think it's the right slide now. It is workplace sexual harassment in the Supreme Court of Canada decision, Jensen v. Plaid Enterprise.
Correct.
Yeah.
Okay.
So you couldn't see it before?
It had been a few slides back before, so maybe there's lag or something.
Yeah, there's just a bit of a lag time. Thanks for giving us a heads up on there. So I think, maybe just wait, 3 to 5 seconds for the slide to show up in front of your screens. Just bear with us.
Thank you very much.
Thanks, Bruce.
Thank you. I was basically reading Justice Dixon's statement on what workplace sexual harassment means. And so he said that workplace sexual harassment may broadly be defined as unwelcome conduct of a sexual nature that detrimentally affects the work environment and leads to adverse job-related consequences for the victims of the harassment. Sexual harassment is a demeaning practice, one that constitutes a profound affront to the dignity of the employees forced to endure it. By requiring an employee to contend with unwelcome sexual actions or explicit sexual demands, sexual harassment in the workplace attacks the dignity and self-respect of the victim, both as an employee and as a human being. And now we will go into the specifics of what workplace sexual harassment or harassment means under the Yukon Human Rights Act. So one part of the definition was that it has to be a course of vexatious conduct. And so what does a course mean? So I'll start by explaining that a rule, which is the inversely proportional rule, applies to what a course would mean. So the more serious the conduct and its consequences are, the less repetition of that harassing conduct is required. Conversely, the less severe the conduct, the more persistence will have to be demonstrated. And so in the 1999 case, Canada versus Canada, the federal court applied this rule and said that the simple fact that the infringement in question is one of harassment requires an element of persistence or repetition. Although in certain circumstances, a single incident may be enough to create a hostile work environment and would constitute harassment. So that is all to say that it could either be multiple smaller events, a course of events which could construe harassment, or it could be one bigger event which could even be seen as sexual violence or sexual harassment for the purposes of the law. The other part of the definition of harassment under the Act is one knows or reasonably ought to know is unwelcome. The conduct is unwelcome. And so what does that mean? What does a reasonable person mean? So the Ontario Human Rights Tribunal has said that a determination of what is reasonable should take into account the perspectives of both individuals, the relationship between them, and any power imbalance. So what would a reasonable person think of that act, of that conduct? Would they construe it as so what does unwelcome mean? It means that the person was not they don't respond well to it, or they would be uncomfortable, they would be made uncomfortable by it, they would be made to feel like it is impacting their dignity and self-respect. So all of those things determine what a reasonable person would consider a conduct as being harassing or not. And the second part is that a reasonable person in this context is someone who does not rely on gender stereotypes or understands what sexual harassment is. And in a brief moment, when Birju discusses power imbalance and discusses some certain stereotypes and myths around harassment, he will also discuss how gender stereotypes and how certain myths around people, for instance, not saying no to the conduct, people because of power imbalance and other factors, not being able to react to harassment in a certain way. What would that mean for a person reasonably knowing that it is harassment? So we will go over that in a little bit as well. So another important part of this test of what is harassment is that, at least for the Yukon Human Rights Act's purposes, the harassment or the act, the unfavorable treatment should be linked to a prohibited ground and a prohibited area. So the Yukon Human Rights Act lists 13 grounds, which are personal characteristics or prohibited grounds on the basis of which you cannot discriminate against someone. And the three that are linked to sexual harassment are sex, including pregnancy and pregnancy-related conditions, gender identity and gender expression, and sexual orientation. So sex, including pregnancy and pregnancy-related conditions, it's self-explanatory, it's very clear. Gender identity and gender expression is basically, so the difference between sex and gender is sex is biological and gender is how a person believes, who a person believes they are and how they express themselves. And so gender identity and expression would mean how a person chooses to express themselves. Like they could be born, for instance, with female genitalia, so biologically female, but they might want to express themselves as what we traditionally would call male. So you cannot harass someone or discriminate against someone on the basis of their gender identity and expression. And sexual orientation is also self-explanatory. It means who you're attracted to. And then the prohibited area that needs to be involved for workplace sexual harassment is employment. The Yukon Human Rights Act lists 5 prohibited areas. So tenancy and housing, provision of services and goods, all aspects of employment, etc. So for it to be workplace sexual harassment under our act, the unfavorable treatment or harassment has to be linked. There must be a nexus between the unfavorable treatment and one of these prohibited grounds in the area of.
My apologies for interrupting again. I just had 2 people come in and say it doesn't appear the slides advanced again. I don't know. I do apologize again for interrupting.
It's all right. Let's see if we can troubleshoot that quickly. Bruce, what are you seeing on your screen?
I'm seeing the Jansen slide still, the workplace sexual harassment slide.
Try hitting escape. The escape button for a second. What about now?
Still, they're advanced there.
Yeah, can you see it now?
Yeah.
Okay.
Okay, so we won't go into slideshow. I think we'll stick with this this format.
Yeah, sure. So what we'll do is we'll stay out of presenter mode, Bruce, and I think just pay attention to the slides as opposed to the speaker's notes. It just might be easier on the eye that way. Make sense?
Yeah. Okay, good.
Okay. So we'll see how this goes, but thanks again for letting us know. And again, if a similar problem arises, just please feel free to interject.
Thank you.
Sorry.
Oh, no, it's okay. Okay, so I guess, okay, I'm not going to go back to the previous slides. I'm just going to move on. So in a recent Yukon Human Rights Board of Adjudication case, the board listed the 4 elements that I've just gone over for finding of sexual harassment in the workplace. So the second and fourth parts you'll notice is the second part is a connection with employment. So that is the area that we just went over. And then the fourth part is prohibited ground of sex. So those were the 3 grounds that I explained in the previous slide as well. And the first and third parts are what does, that there should be a course of vexatious conduct, or one should know or ought reasonably to know that their conduct is unwelcome. So basically all of the factors that we've just gone over that create the definition for harassment under the Yukon Human Rights Act, the board relied on them to determine whether there was sexual harassment in the workplace or not. So now we have a few slides going over what sexual harassment in the workplace could mean, because workplace sexual harassment can be very nuanced, it can be very subtle, and it can also be based on a lot of gender stereotypes and myths and just a sort of workplace culture, which may be poisoned, but people don't realize that it is poisoned or that it constitutes harassment. So we have a few slides discussing what workplace sexual harassment could look like. So one of them is sexual solicitation and advances. It is one of the more straightforward ones, and there was a recent case, Basic versus Escomalt Denture Clinic, 2020 BC Human Rights Tribunal case, which involved the respondent who was found to have discriminated against the complainant on the basis of sex. doing most, if not all of these, the listed conduct here. And again, the tribunal found that it was sexual harassment. I'm not going to read them. They're quite straightforward. Sexual violence. And we just went over how it could be a course of vexatious conduct, but the courts have also held that it could be one single conduct that is so vexatious, that is so unwelcome, that it could construe sexual harassment. So sexual violence, of course, is discrimination and it is harassment. So any act that is a single act, but it is so severe and so, discriminatory and wrong, could be sexual harassment for the purposes of the act. And then gender role based harassment. So it's comments like women in the office should get the cake for the party because women are good at it, or we can't hire a man for the role of, for instance, a caregiver because women are generally good at that stuff. So any of these comments, which may seem like, well, it couldn't be harassment because that's how things are, could actually be harassment under the case because you're basing certain roles, you're prescribing certain roles to certain genders, and that may end up being harassment if that puts someone in, in an unfavorable situation or it's unfavorable treatment. And poisoned work environment. So all of these things listed here can contribute to poisoned work environment. And of course, sexual harassment can lead to poisoned work environment. One thing about this aspect specifically of sexual harassment is that sometimes people may be saying things or displaying images, or their conduct is in a way that is actually harassment, but they don't realize it because they believe that this is appropriate in their workplace. So that does not mean that there is no harassment. That only means that the culture is so poisoned in the workplace that people don't realize, employees don't realize that it is harassment. And Birju will go over this in more detail as well later when we're talking specifically about sexual harassment in the legal profession. And I'll hand over the stage to Birju now to go over what sexual harassment specifically means in the legal profession and what are our responsibilities in regards to that.
Thank you so much, Amna. So this part of the presentation will focus now specifically on sexual harassment in the legal profession. So some of the things that we'd like you to consider is going to constitute the subject matter of most of the next few slides. So what do we know about sexual harassment in the legal profession? So I'll start first by pointing out the 2018 International Bar Association report. Nearly 7,000 individuals from 135 countries responded from across the spectrum of legal workplaces. 1 in 3 female respondents had been sexually harassed in a workplace context, as had 1 in 14 male respondents. So as you can see, that's a rather large study, international, and these are troubling and alarming numbers. 1 in 3 female respondents, 1 in 14 male respondents. This is specific to the legal profession internationally. Second, we have the 2018 Law Society of Ontario survey of articling students. 21% of the 1,471 respondents answered yes to face unwanted attention or harassment. So there again, that focuses more in Ontario, in Canada. Again, that is a troubling statistic. So 21% is not an insignificant number by any means. Large number of respondents there. The next 2 bullet points focus on workplace sexual harassment more generally. So 2018 Statistics Canada Harassment in the Workplace survey found that approximately 19% of women and 13% of men reported experiencing harassment in the workplace. And lastly, something to be said about Yukon. We have very little data, but since our founding in 1987, the Commission has regularly received complaints about workplace sexual harassment. According to our internal data from 2019-2020, the second highest number of accepted complaints were on the ground of sex, and the highest number of accepted complaints were in the area of employment. So again, this is certainly a significant problem. All the statistics bear that out, both internationally, locally, and of course, in the territory. While we don't have a lot of specific data, we can tell you based on what we do here at the Commission that it certainly is a problem. The next few slides, Amna and I selected very specific areas to focus on. That was partly owing to the time limits or time constraints with respect to our presentation this afternoon. There are many, many more things that could be said about sexual harassment in the legal profession, but we decided to select those areas that we think require all of our attention as members of the legal profession in some way, shape, or form. So we're going to start with articling students. Hopefully that doesn't bring back too many nightmares for all of us in terms of first year in the profession, but articling students is something that's very important to focus on for a number of reasons. First, power imbalance. I will say that a lot of what we are saying, however, about articling students could be said anywhere where you find a power imbalance. So it can include, for instance, support staff, assistants, paralegals who are working under associates or other partners. Wherever you see a power imbalance, a lot of what I'm about to say could be echoed and mirrored there. However, with articling students, what's noteworthy is that firstly, depending on the jurisdiction you find yourself, articling students may not attract the same level of protection in labor and employment law as support staff, paralegals, et cetera. So that's the first thing that's noteworthy about articling students. Second thing is that articling represents an entry from the standpoint of licensing into the profession, as distinct from other types of legal work where you have a power imbalance. So an articling student is not simply embarking or has embarked on a career yet, but is fulfilling a licensing requirement which will dictate how the rest of their career goes, which effectively means that when they experience harassment in this context, it's not simply affecting a quote unquote job that they're performing. It may very well have consequences later on for their careers and impact whether or not they have access to the career. Important to mention that at the outset. So in terms of power imbalance, because of the power imbalance in the supervisor-supervised relationship and the perceived consequences of objecting to a supervisor's behavior, the supervised may go along with unwelcome conduct. And so the case of Reese Simpson, 2005, addresses those facts. So it's important to know that people will go along with behavior, not because they have a choice. And this circles back to the idea of consent. So consent is, we have to think about it not in terms of saying yes or the absence of saying no, but we often refer to the idea of enthusiastic consent, which is also called affirmative consent in some of the literature. So consent has to be active, it has to be emphatic, it has to be enthusiastic. It isn't just saying yes, it's not the absence of a no, and one needs to look at the overall context. And whenever you have a power imbalance, that needs to be an automatic flag. So one has to look at power imbalances all the time, consistently, frequently, and as has often been said about consent, consent is also not a one-time thing. It's about checking in constantly and reevaluating things as you have further information. So that could be said here as well. Second thing, or the second bullet point, is around the fear of retaliation. So pursuant to section 14, subsection 1 of our act, the Yukon Human Rights Act, it states that no person shall B, retaliate or threaten to retaliate against an individual who objects to the harassment. So in some respects, this may constitute a separate infraction, a separate area of infraction. So something worth being cautious about. There's a case here that we've referred to, Bell and Korczak, 1980, rather old case, but it has been cited frequently. The continued willingness of an employee to work is found not to constitute acceptance of the harassing conduct. And this probably comes as no surprise to many of you, but there is no standard way in which a person who finds themselves a victim of harassment behaves or operates. So there have been a number of well-publicized incidents where this has had to been repeated. I'm referring now to the case of Justice Robin Camp in Alberta, who relied on a lot of stereotypes with respect to victims of sexual assault. Unfortunately, this is pervasive in the legal profession, including in the judiciary. So there is no standard way in which someone responds to sexual harassment. So this is an example here where someone's willingness to work or continue to work should not be construed as accepting harassing conduct or accepting harassing conduct. And another thing to be said of articling students and others that I've mentioned is that there are circumstances such as it's intersectional. So circumstances such as socioeconomic background, particularly lower socioeconomic backgrounds. Some people enter the profession for the first time after overcoming certain socioeconomic backgrounds, people of racialized communities, members of the indigenous communities are oftentimes the first people in their family or even their community to enter the legal profession. And there's a difference between that and someone, for example, whose parents or partners in large national or international law firms who may have more options. So all of that means that certain people are more susceptible to having to make those difficult choices, and people in a position of power have to be aware of that. So a lot of this operates intersectionally. We were thinking a lot about articling students for the reasons that we've mentioned, but again, as I've said, much of this could be said to anybody that finds themselves at one end of that imbalance in power, whether that's a member of support staff, assistants, paralegals, etc. And that's worthy of bearing in mind and being vigilant about. So the next couple of slides are going to focus on clients, how we navigate around sexual harassment, where that's perpetrated from a client and not necessarily a senior partner or a supervising lawyer or even another lawyer or coworker at, let's say, the same firm. And so the Saskatchewan Human Rights Tribunal, in a case Nixon and Greensides back in 1992, their Human Rights Tribunal held that the consideration of harassment of an employee by customers of the employer falls very much into the same category as harassment by one employee of another employee. It is clear that the employer has the obligation to take steps to deal with harassment by other employees once the harassment is known to the employer. Sexual harassment has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. The employer has an obligation to prevent that from happening, and the employee has the right to expect that the employer will take those necessary steps. So one of the takeaways here is that employers are responsible for the conduct of clients. So if it is reported to the employer that they're being harassed by a client or another customer or a contractor, the employer has obligations to take that seriously and to respond. It doesn't matter that there's no overall quote unquote command responsibility from an employee, or as the case law used to describe it, master servant relationship. Before getting into the workplace culture, another helpful case to consider in terms of what we've said around the issue of whether it's clients or customers or others, we can stay on the next slide, is the case of shrink. So factors that inform whether the discrimination has a sufficient nexus with the employment context include whether the respondent was integral to the complainant's workplace, whether the impugned conduct occurred in the complainant's workplace, and whether the complainant's work performance or work environment was negatively affected. So that's from the Supreme Court of Canada's judgment in the BC Human Rights Tribunal and Shrink. And so it's important to know that there is responsibility placed on this, not just on clients, but for others, and that the employer may bear responsibility for it, or others may also bear responsibility for it. So in Shrink, the fact that someone works at different law firm or is an influential customer or is a subcontractor or is an outside contractor or an agent, human rights complaints can be brought against all of those categories of persons in the context of employment. And it's an appropriate segue to discuss workplace culture. So workplace culture, if inappropriate, can lead to a poisoned work environment, as Amna mentioned, and there are significant consequences. So one of the things that is important to discuss here is former Supreme Court of Canada Justice Bastarache, who was responsible for putting together the Broken Dreams, Broken Lives report, which looked into over 30 years of harassment in the RCMP, observed in his report, and this is a quote, "Culture eats policy every time." It isn't enough to have workplace policies that deal with harassment or violence in the workplace if the culture, number one, is not aligned with whatever values are contained in those policies, and that those values and workplace culture is not practiced. So walking the walk, as it were. And we certainly know this, that where, especially from the top down, if the culture is not conducive to a healthy work environment, including sexual harassment, policies are meaningless. And one of the interesting things that Justice Bastarache said when giving evidence to a parliamentary committee, he observed, "I have a list of RCMP officers who have been found guilty up to 15 times. Those people have been promoted. This is despite the presence of policies that the RCMP had, which ostensibly had made harassment, including sexual harassment, illegitimate in that workplace." So accountability is important. And this is particularly true in industries where expertise is necessary, such as law firms. So sometimes, in fact, oftentimes, the overriding criterion for individual success and team success is someone good at what they do. You have that effective member of your team who's incredible when it comes to mergers and acquisitions or foreign markets or foreign capital markets. And there's a sense of wanting to reward that and minimize the things that certain people do badly. But we should not shy away from accountability. Doesn't matter how technically successful or technically savvy someone is in their work environment. We know that, again, to echo that quote, culture eats policy every time. What we've discovered in our own line of work is that is true. We would echo Justice Bastarache's thoughts there. So really important to be aware of that. Workplace culture is important at every levels, not just top down, and it includes people that don't necessarily work in the firm. It's also important to point out that the workplace is not limited to the physical bricks and mortar location of the office. It can include Christmas parties, it can include weekly drinks, lunches, anything where the workplace relationships can be affected. And this is also important from a cultural standpoint. It is great to make the workplace fun. It is great to have workplace parties. It's good to go for drinks, although those places should be inclusive places. Not everybody, of course, drinks. The workplace should be made inclusive and fun, but it's important to understand that the workplace does not stop when people leave the doors of the office. And that does also impact culture. And when we say impacts, what are some of the impacts, both on the employer and the employee? Because there are impacts for both. And some of these do intersect. Some of them are the same for employers and employees, but just to go over some of them, and these can be long-term, they can be harmful to the targeted individual and at the workplace as a whole. For the employer, it includes the creation of a poisoned work environment, which is very, very difficult to undo, expensive to undo, better to get ahead of it than to be in a position of having to undo all of these things once a poisoned work environment has taken hold. It leads to reduced productivity. It leads to a decrease in public safety and safety in the office. It creates a problem when it comes to talent retention. So naturally, people are going to leave. And talent is hard to find, especially in law firms. Reduced attendance. You're going to have problems with absenteeism in the workplace. And there are financial costs, not just from the standpoint of liability, both in terms of human rights and elsewhere, but there are financial costs with the above things that we've enumerated. And as I've said before, to fix these problems can be expensive. It's better to get ahead of these problems. So to be on your toes than to be on your heels, as the expression goes. The effect on employees, likewise, many of them, you have injury to feelings of dignity and self-respect, which shouldn't be underplayed, very important. It impacts mental health and well-being. It diminishes morale. It impairs job performance, and it decreases job satisfaction. One way to look at these is that they're mirrors of one another, depending on whether you're the employer or the employee. So it has a corresponding effect both ways. Adverse job-related consequences are broadly defined and may include termination, reduction in hours, lack of advancement, opportunities, and can also include the consequences of working in a hostile or poisoned work environment, as was found in AVA on behalf of others and Spruce Hill Resorts in another, which was a 2018 decision of the BC Human Rights Tribunal. And so that, of course, gives rise to our responsibilities. And our responsibilities isn't really ours as members of the legal profession, but we all have responsibilities when it comes to the eradication of workplace sexual harassment. So what are our responsibilities? A lot of this will focus on employer responsibilities, however, but just to emphasize that we do all bear, to some degree, responsibility for eradicating workplace sexual harassment. And so Section 35 of our Act states that employers are responsible for the discriminatory conduct of their employees unless, emphasis added, it is established that the employer did not consent to the conduct and took care to prevent the conduct, or after learning of the conduct, tried to rectify the situation. What this is doing is it's codifying the principle of vicarious corporate responsibility, that by and large, employers are responsible for the conduct of their employees, and there are exceptions to that. The exceptions are few. They are to be construed narrowly, and they haven't been tested. At least this provision, to my knowledge, has not been tested in the territory. Though, of course, the principle of vicarious corporate responsibility is a common law. Employer responsibilities, in terms of the diagram in front of you, you can look at this in terms of being a three-part approach. The first is the employer is responsible for providing a workplace free from discrimination and harassment. The employer is also responsible for investigating complaints when discrimination and harassment are reported to them. And employees' behavior, the employer is responsible for employees' behavior in making efforts to fix or remedy the situation. Employees' responsibilities in case law form, probably one of the more often cited cases across the country is Leshkowska and Marine Land of Canada back in 2005, cited hundreds of times across the country at numerous levels. This is a good way to construe the employer's responsibility around their duty to investigate. And this is one that gives some employers, actually a lot of employers, trouble. So in Leshkowska, it set out these issues, again, 3 parts. The first is the awareness of issues of discrimination or harassment and a policy complaint mechanism and training. So this is what is communicated and set out before there is a complaint. And it's looking at what exists in terms of policy and complaint mechanisms and training. So questions that a tribunal will ask is, was there an awareness of issues of discrimination and harassment in the workplace at the time of the incident? Was there suitable anti-discrimination and harassment policies? Was there a proper complaint mechanism in place? Was adequate training given to management and employees? Next, we have post-complaint. This is typically when something has now been reported to the employer. So the employer has to take things seriously, has to deal with it promptly, and has to take care of its employee or employees. Investigate and act. Once an internal complaint was made, did the employer treat it seriously? Did it deal with the matter promptly and sensitively? Did it reasonably investigate and act? And some of the things, again, we're thinking about there in terms of how an investigation is conducted are things that all of you will be familiar with. They're very similar to procedural fairness or allegations put to the other side. Is the complainant then given an opportunity to rebut some of that? What are the relationships between the investigators? Do the investigators have training, bias, impartiality, all of those things? And lastly, resolution of the complaint, including providing the complainant with a healthy work environment and communication. Did the employer provide a reasonable resolution in the circumstances? If the complainant chose to return to work, could the employer provide them with a healthy, discrimination-free work environment? Did it communicate its findings and actions to the complainant? So those are some of the employer responsibilities. And of course, these are taken very seriously. Very recently, in what was then a landmark decision of the Ontario Human Rights Commission, in a decision called NK and Badiak, which was decided back in March 2020, a complainant was awarded $187,000 in general damages, not only because of the serious conduct, serious sexual harassment over a lengthy period of time, but the employer did not adequately investigate and in fact terminated the complainant. So the Ontario Human Rights Commission did send a message to employers that that employers need to take the responsibility to investigate quite seriously. And on the question of shared responsibility, we have, as a lot of you may know, new occupational health and safety regulations, which now make harassment an actionable issue. So sexual harassment is a workplace safety issue. It's also a labor relations issue. So unionized employees can file a grievance under their collective bargaining agreement, which can be advanced to arbitration. And labor arbitrators have concurrent jurisdiction with the commission and may award human rights remedies, including general damages. It's a regulatory issue in the sense that the Federation of Law Society Model Code of Conduct, section 6.3, prohibits sexual harassment, and discrimination. And lastly, bystanders, and often neglected, but especially recently, more research has been done on this. It's part of the conversation now more than it has been before. Very important area to look at. And research is increasingly recognizing the role of bystanders, and bystander training is offered by a number of organizations across the country. If people are interested, that's a situation where certainly call a Human Rights Commission. We can attempt to assist with this, and we will be addressing this in our project that Amna referred to at the outset of the presentation. Bystander training, very important, very recent in terms of the research. Large role, not just in terms of bystanders as being impacted, but also what is called ethical disruption. So how bystanders can be part of the solution, intervention, and prevention mechanisms on sexual harassment. So this slide is our process. I'm sure many of you have seen it. It's also available on our website. So I'll just say a few brief things about this now. The Yukon Human Rights Commission's complaint process, things to note about it: inquiries are free, of course, as well they should be, as is filing a complaint and anything else involved in our process. It is confidential until it reaches a public hearing. And even then, in terms of sexual harassment, an application can be made to anonymize. The process is remedial, not punitive. So our job is not to punish people, it's to, in a sense, be remedial. However, it should be noted that in terms of remedies, they should not be such that it simply encourages discrimination or reinforces the idea that people will pay a discrimination tax. It has to be sufficiently deterrent or have the capacity to deter in its essence. And then we have a nice, lovely flow chart. Given that I did not draft it or design it, but it gives you a nice indication of the steps in our process. So when a complaint is accepted or not accepted, what are the steps? As you'll see, there are two opportunities for settlement. One is early resolution. And after disposition, there's another opportunity to settle. It's the purple stuff is us as the commission, what we deal with. The orange stuff is public hearing, which is dealt with by the Yukon panel of adjudicators, which is an independent body from us. And at that point, we're in public hearing territory.
One thing I do want to note, which is not in the slides, is that the commission is a neutral body. So we don't advocate for any of the parties. We just move the case forward and we encourage settlement throughout the process, as Birju just pointed out. And if you want to find out more about our process, it's available on our website as well.
And if you have any questions beyond the question and answer session, here are our details. So you can reach us by email, telephone, toll free. Apparently some places still have fax. I'm told the industry where faxes proliferate the most are law firms. So perhaps fitting that we have our fax number in there. We will respond, I suppose, via fax. Well, we might not necessarily respond via fax, but we can. But we do accept faxes. And you're always more than welcome to come see us in person. COVID rules have been relaxed. Our preference is still that people wear masks, but please feel free to stop by. That would be great. And I think, Bruce, I'll turn it over to you to moderate the question and answer session.
Thank you, Birju. Yes, so at this point, I'd ask that anyone who has any questions, please put them in the Q&A function or the chat function. I haven't noticed any that have come in yet, but we certainly do. This is certainly your chance to get some input and get some of your questions answered. I think, yeah. So please feel free to ask questions.
Any takers?
Here we go.
Perfect.
Oh, I have to leave the event. Well,
Okay.
thank you for coming by.
Should I open the chat?
Yeah. Oh, you know what? It's
Okay, thanks, Lynn.
I guess our presentation was so good, no one has anything to ask.
yeah, right.
We were so thorough.
Maybe I'll just spell out something to try and get some things going a bit. So maybe talk a bit more about all these different concurrent jurisdictions and how perhaps we can help people navigate these various jurisdictions. For example, in the worst cases, you're going to have a human rights complaint, a workplace health and safety complaint, a professional body complaint, and a criminal complaint, all dealing with the same complainant. And I just think it's something that I could certainly see being a bit overwhelming for someone who is in those situations. So what are the tools or things that we, if we're working for someone who is in these situations, that can help them navigate these things?
You want to answer or want me to answer?
Well, I'll briefly just say that, so the Yukon Human Rights Commission is, so we are an avenue of last resort, which means that we do encourage complainants to exhaust other avenues available to them for filing grievances and availing any other procedures available to them that can deal with human rights issues or issues of discrimination. So when people do come to us, we do ask them, are you unionized? What are the other avenues that you can avail? If they are not aware of where they can go, we do share resources with them as well. And once they have exhausted those processes, they can come to the commission. But I'll leave it to Birju to explain it further.
And what I'll say by first noticing that there's been very little Latin thus far, so I'm going to start with a little bit of that. So in terms of the concurrent jurisdiction, to the extent that those among you who are familiar with the doctrine of res judicata, there are certain bodies, of course, and Anna's pointed to a few of them. So where a member of a collective bargaining unit or a union has the option to grieve something, by virtue of our act, they have to exhaust that process, partly because that can be advanced to arbitration. An arbitrator has concurrent jurisdiction. So we will suspend our process pending the outcome of that. There are other bodies that may also have concurrent jurisdiction. The courts, of course, don't. Criminal proceedings would not be one of them. Again, we would carry on. Occupational health and safety is a little bit more interesting. So for res judicata to apply, the body has to be able to award damages which are fundamentally, or I don't want to say fundamentally, that are similar if not identical in nature. So you can't claim twice for the same thing. If the consequence of, supposing you report it as a workplace safety issue, and all that will come from that is an administrative penalty issued to the organization, in that scenario, we would not suspend a process. So in that sense, you can file two complaints based on whether or not there's a remedy and whether or not that remedy is substantially similar to the sort of remedy that you're going to find in a human rights process. So in the case of a union grievance that goes to arbitration, yeah, I mean, that would, the doctrine of res judicata would apply. In the case of regulatory bodies who could deal with the subject matter but would issue administrative penalties, That's where a complainant may want to decide which route they want to go down. There are positives and negatives and pros and cons associated with both. But as far as our process, as a general rule, you have to exhaust every other process available to you. But there are certain processes that can't make determinations of human rights law and that cannot award similar remedies, and therefore you can go in multiple directions. I.e., let's say a claim for constructive dismissal in the courts and also a human rights complaint, for instance.
Thank you very much for that explanation. Here's a good one from Lynn. Do you have any resources available to workplaces that are trying to develop policy around sexual harassment in the workplace?
Sure. So actually, fairly recently, I think this is about maybe 2 months ago, we had a 30-second radio spot on some of the radio stations in the territory that discussed the fact that we do help with that, certainly. So for organizations that want us to review policies, that's something we can do. So what I would say, there may be some resources on our website, but give us a call around that. Certainly, we are probably going to be that resource. So for any organization that wants to develop effective policies, that would be us.
But I do want to identify the fact that we don't create policies
That's
from
right.
scratch for organizations, but we will give you information and we will review your policies and we'll tell you whether they're adequate or not under the law and under the Human Rights Act. So we are more than happy to do research for you to review your policies, but we can't create policies for organizations.
And that's actually a good point on Amna's part. So if you email us saying, I work for, whatever company it is, or I represent, Acme Oil Corporation, who does not have a sexual harassment policy, can you draft one for them? I mean, we would not be able to do that. Unfortunately, for a number of reasons, including going to have to spend money doing that. But we can review policies. So that was it. Thank you on that timely and relevant intervention there. And hopefully that answers the question.
Thank you very much. That seems like a very good and helpful resource. I'm just going to go ask maybe if there are any more questions. Maybe we'll wait another 5 minutes, and then if there's no further questions, we'll thank Birju and Amna for the time and the excellent presentation and somewhat early.
Thank you.
And certainly invite the two of you to add any further closing comments you'd like to add. Well, I guess we'll just thank everyone, since I know you did provide both of you emails and some availability if there's any further questions after we close things today. So thank you very
Bruce.
Very much for joining us today. There's an upcoming CLE on the changes to the Wills Act, and as chair of the CPD committee, I'd invite everyone to attend that. And if you have any, I'll invite our two presenters to give any final closing comments.
Well, I will just say, I'd like to thank all of you for joining us this afternoon. I hope that you found this presentation helpful and in some ways instructive. And again, if you have any questions, or even if you just want to talk about anything that we've discussed, we're always available. Feel free to reach out to me or, to Amna with any questions, thoughts. But thank you all for attending. Amna?
Yeah, I just want to echo what Birju said as well. Thank you very much to the Law Society and for all the participants who came to the presentation today. I do apologize in the beginning for the voice issues and the The slide's not projecting. I have no idea why that happened. We will try to resolve that and figure out why that was happening here. But thank you so much. And yeah, the commission does a lot of great work, and our fight against workplace sexual harassment in the Yukon is one of our major projects as well. So feel free to reach out to us. You can contact us, you can call us, you can email us at info@yukonhumanrights.ca, and our website has a lot of useful information on this subject as well. So you can visit the website as well. But thank you so much for giving us an opportunity to talk about this important issue.
Thank you.
Thank you.
Bye.
Bye.